Yes, Dr. Lal.
No library talk this time, my lord. But start again, my lord. I appear for the JK People's Conference, my lord, in writ petition 1165 of 2019. A question that your lordship put to Mr. Sibal was, have you challenged the presidential proclamation of 19th December? We've challenged the suspension, my lord, and that is very important to our argument on Article 3. There is also another petition, my lord, Sohail Qureshi 1068 of 2019, which actually challenges the proclamation.
2068, right?
1068. Now, my lords, I would begin by saying, as well from my lord the Chief Justice, that this oral submission is in the nature of a dialogue, and a very important dialogue, which even the US Supreme Court doesn't have. They assume everything is read and there's a bit of question and answer and that's it. And it is because of the nature of the dialogue, we have to, on an ongoing basis, answer what fell from your lordships as well. I'll give your lordships an example. My lord, the Chief Justice made a reference to 249 and 252. Of course, they are of a different genre. But nevertheless, my lord, that question is very, very important for us to build the diversity argument, and whether there is transformative constitutionalism, whether there is a basic structure, whether that's a lost cause or not. Then, my lord, your lordships had asked questions about Article 3(1)(d) and whether Article 370 subclause 3 survives. Now, this is important because it's been used only twice. It was used in GO 44, my lord, and now it has been used once again in GO 273. Now, if it doesn't survive, my lord, how can it be used in this particular way? We have to answer that question for your lordships. In addition to that, my lord, there seems to have been some confusion or misunderstanding on the status of merger agreements, my lord. The question that fell from your lordships was that once the instrument of accession is over, sovereignty is complete. Our respectful submission, my lord, on this, which I will elaborate. I've done it in a note, my lord. Like Mr. Zafar, I'll hand over that note, my lord, to your lordships. My lord, 3.7, as far as the instrument of accession is concerned, it deals with external sovereignty. Kindly bear this in mind, it's very important. External sovereignty is lost. Internal sovereignty is not lost. That is why in Premchand, they say the monarch was still an absolute monarch. Premnath Kaul, sorry. So, what the purpose of the standstill agreement was, what system would you have in the meanwhile? The state of the Raja of J&K didn't sign a standstill. The records show there was some toing and froing and eventually, which means he retained all his power. So as far as internal sovereignty is concerned, the standstill was very important because all the powers of the Maharajas and the coming states, my lord, retain their internal sovereignty. Now come to the merger agreement. The merger agreement is important, my lord, because it finally indicates the extent of internal sovereignty. If there was no standstill agreement, and if there was no merger agreement, my lord, the Maharaja would be absolute, as Premnath Kaul says. So I take 370 to be, my lord, a substitute, a constitutional substitute for a standstill and merger agreement, without which, my lord, we are lost. And I'll explore that, my lord, later when I come to 370. Your lordship also, my lord, put a question to Mr. Zafar Shah that on the 4th of August, what were the autonomies that you were going to lose? He promised you a list, my lord. One answer to that is everything, but I will indicate what these autonomies meant and what was lost for Jammu and Kashmir, which comes back to Justice Kaul's question, are we flogging a dead horse? The answer is no, my lord. It continues, and it has to continue to preserve, my lord, the federation and the conditions under which the federation was created. So let me begin with what I began with the other day, my lord, and that is that we have the greatest diversity in the world. Take many continents together, take many countries. This diversity is unparalleled. That is why, my lord, Professor Ravinder Kumar, I asked him, I said, what should I say in my Colombo lecture? He said, say that the Constitution of India is a constitution for a civilization with many nations and many cultures. And this is what makes our constitution more exciting than any other. On the question of diversity, I was taking your lordships to done a list which I'll give to your lordships, my lord, but I was going to invite your lordships' attention to Article 3 first. But I'm going to read one important aspect of it, my lord, and that is the proviso which says that before anything is done under Article 3, it is mandatory for the president to refer the bill to the legislature. Mandatory. It's a condition precedent before you invoke Article 3. Just as there are conditions in Article 370 which have to be fulfilled by condition precedents. Now on Article 3, my lord, the proclamation of 19th December virtually created an amendment of Article 3 by taking the condition precedent out. Mr. Sibal read all that to you, but I want to refer your lordships, my lord, to that particular part of the proclamation. This your lordships will find in volume 3 documents.
Page 92.
And the PDF, my lord, I'll just give it to your lordships.
Page 92.